next matter to come before the court this morning is State of Ohio versus Morgan Christopher LaSelle. Both sides, as you know, will have 15 minutes to present oral argument. Oh,
It's more comfortable here.
I never get to sit there.
What, if you want to move the name tag though, as part of that, you can leave do that.
Your Honor always has the more practical solution to things.
please don't use the names of any victims or minors. We are recording, as you know, and this case will be posted on the court's YouTube channel. Yeah, so it's even a little strange for me. You have 15 minutes, and you may reserve any, up to 5 minutes for rebuttal. Would you like to reserve any time for rebuttal?
Yes, Judge, could I reserve 5 minutes?
Certainly.
Thank you. Good morning again. I'm Rick Raley, appearing on behalf of the appellant in this matter, the state of Ohio. We're appealing from the trial court's order of dismissal of an indictment for F4 failure to register. The basis for the defendant's registration obligation is a 2008 conviction in North Carolina for sexual battery. The trial court concluded that it was subject to dismissal, though, because it concluded that the defendant was actually not convicted as an adult in North Carolina, but adjudicated delinquent as a juvenile, and therefore had no registration requirements. We're presenting this issue now for that you should overrule that decision for two reasons. Both are independent, they're both sufficient by themselves to overrule. Number one, I think the trial court's order embraced the general issue for trial, which is violation of 12C. Even if the decision was okay under 12C, the evidence in this matter does not indicate that the defendant was adjudicated as delinquent as a juvenile, but actually convicted as an adult, and therefore had a continuing registration obligation. Before I move into that, I do want to emphasize what this is not about. This is not about timing and tolling and Megan's Law versus Adam Walsh Act. There was a hearing in this matter. The offense date that's reflected on the judgment entry from North Carolina is that the offense occurred in September 2007. That means Megan's Law would have applied. The conviction was February 2008. Under Megan's Law, this offender is a sexually oriented offender, which has a 10-year registration requirement. At the evidentiary hearing, there was also evidence received that there was tolling of that requirement due to noncompliance and incarceration for 918 days. That extended his registration requirement all the way to September 2020. The indictment periods for August of 2020. Those were not issues that were raised below about any incorrect calculations or anything related to that. So that's why I think the defendant has filed supplemental authority for State versus Schilling. That's really inapplicable here because that addresses issues relating to tolling and those issues. That's not here. So I'd like to start with the general issue of trial. And under 12C, there's no summary judgment in criminal cases, as we all know. And I think essentially that's what the trial court's judgment is. It's a summary judgment. State versus Palmer is their authority that the trial court used to say that it was appropriate. But Palmer had to do with just the date of conviction clearly showing that there's no registration requirement. That's not what happened here. Here there had to be a factual finding about whether there was actually a registration requirement and then if it existed at the time of the indictment. That goes far beyond just looking at the face of the indictment. So I think under that, this should go back for that issue and it should go to the trial. However, even if we are to look at the evidence from that North Carolina judgment entry, nothing in that entry indicates it's juvenile adjudication. North Carolina, much like my home state of Maryland, is a state where there is no juvenile court. There's actually a court that applies to everybody. If it's a juvenile action, it gets referred to a magistrate. Under the laws of that state, they also have conviction versus adjudication. The entry refers to a conviction. The judgment entry also refers to probationary conditions under the North Carolina Code provisions relating to adult probation. Because of that, and no reference at all to the fact that it's juvenile adjudication, the court had to find it was an adult conviction. To the extent that it didn't, it has to go back, and this has to go to trial. And based on that, all the briefing that we've received, I'd ask you to reverse.
It struck me as odd in the brief that the judgment entry starts right out with, this was an adjudication in juvenile court, but where would that have come from? Just a reference by the trial court judge of the age at the time? I I can't understand how it can be so clear one way and so clear the other way.
I believe that there may have been just some application of Ohio law and understanding to this North Carolina judgment entry. Clearly, if a 16-year-old's charged here, it would have been in juvenile court, but that's not how it works in North Carolina. And that was presented, and the general statutes of North Carolina are accessible to everybody, and they clearly show that this is an adult conviction. So I really don't know where it came from, except for constantly the defense counsel below is saying, no, it's an adjudication. Adjudication. He was under the age of 18. Must have been adjudication. But that's not what the evidence says in the judgment entry.
But then there are things in the record from the North Carolina court, right?
Yes, they are.
Because that would be necessary to
Correct.
show that he had to register. And there were arguments about what those things were through the motion procedures, right?
Correct. There was argument and there was representation that it must be an adjudication. And there is, the big hang-up was the judgment entry says that he is ordered to register by statute. And the defense below took that to mean, well, there had to be a finding of danger to the community because he was a juvenile, and that's just what we think applied, and that's what the judge should go along with. And I don't see any basis for why that should have been gone along with.
But the state is asking us to not analyze the things that the trial court analyzed when they found, because under 12C, the state is saying, you know, that went well beyond what was actually in front of the court.
I think you can do that, and if you choose that, because of Palmer, that you don't want to go down that path, and you go to the merits of that decision, the merits don't work here either. So that is what the state's position is on appeal. Either way, there needs to be a reversal of that decision.
Was there, I know there's motions and argument and everything, was there anything hearing?
Pardon?
Was there a hearing?
Yes, there is a hearing. There's about a 57-page transcript from that hearing. The detective from Summit County Sheriff's Department who was assigned to this case testified about those tolling issues I went over earlier. There was representations about what North Carolina law might be, but those were all legal questions that really had to go to researching and pulling the books from the stacks. Or go down to Westlaw.
There was a decision from North Carolina, obviously submitted, was an indictment or something similar to that admitted into the record?
No indictment from down there. There was, the judgment entry does refer to the offense date and refers to the statute under which he was convicted. That I'll reserve for rebuttal.
Thank you, Counsel.
If it please the court, Mark Ludwig for the defendant, Applee. The Tuesday began with the privilege of appointment by this court. This morning began with the privilege of appointment by Judge O'Farrell. And this case appointment comes from Judge O'Brien. I feel a special burden to uphold her decision as a first in 50 years. I think I'm standing here saying the trial court got it right, and she did. Now, my concern here first is whatever this entry says, it says this young man was a minor when he was charged. Now, I don't know a darn thing about the North Carolina system of law, but I do know that he was 17 when he was charged. Megan's Law, period, the end, no more. And I think Schilling and Reyes both have sent a message to this court about, nice to know they're loose, sent a message to this court about, look at these carefully. This is a horrible area for me to understand. How this is not a summary judgment, 12C, how those are not even allowed. Just, the court said so. You've got to work with that. These cases are different in terms of how deep do we look at the indictment. Oh, there's some good language about you don't look at facts and all that. But these are tougher for that reason. And I think Schilling and Reyes both say, stop. This was a Megan's Law case, 10 years. I'm reading the transcript and I'm saying to myself, whoa, wait a minute. I've got a police officer sitting here telling me what North Carolina law is? Nobody objected. I'm not saying, and I've had the privilege of knowing trial counsel since she was admitted in 1988. Very competent lawyer. But the problem I have with this case is we're sitting here not applying Ohio law. How many times has the appellant said, North Carolina law did this, North Carolina law did that? Wait a second. We're not applying North Carolina law other than in the context of our law. And for example, North Carolina's statute is not comparable to our sexual battery statute. Our sexual battery statute is very detailed, 8 or 9 subsections. That's not North Carolina's law. They don't really compare in detail. If the trial judge got anything wrong, she got it wrong saying that they're the substantially equivalents. There's another out for you if you want to take it. I don't know that you should. I don't know that good law is created in this case by any decision other than we affirm the trial court, period. These are going to keep coming back to you as long as the prosecution decides this kind of case needs prosecuting. Between Schilling, Reyes, and this case, I think maybe some of these cases will start to drop off. But this guy is how old today and how many years of reporting? This case should be affirmed and the indictment remain dismissed. I'm sorry, Judge Stevenson, I read your decisions on double jeopardy wrong, as the prosecution points out. And right now, it's probably a moot question because you shouldn't need to speak to it. But if this case is reversed, back we come arguing res judicata unless you address the issue. Thank you, Your Honors.
Thank you.
Just briefly, Your Honor. North Carolina law is very important to determine whether there's a registration obligation. That's why it is critical to this court's resolution of the issues that are raised before it. There were questions asked of the sheriff's deputy by defense counsel about North Carolina law. She had him read portions of the statutes that she thought were relevant. It's to this court to look at the actual North Carolina clues that are applicable as I read to you. So I'd ask that you reverse the trial court's entry. And we can go from there. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a decision which is known to all parties of this appeal by the clerk of courts on the day that it is issued, as well as posted on the Ohio Supreme Court website. Our next oral